Hello and welcome to today's episode of Legal Wrangle, where we will present before you excerpts from some decisions rendered by various high courts pertaining to custom law and which enunciate the latest legal developments in this field. Let us begin with the first case at hand. The petitioner company herein had imported a consignment of goods and filed the bill of entry. However, the goods were seized and detained by the Customs Department. Thereafter, provisional release of the goods was directed subject to the importer fulfilling certain conditions. On appeal, the tribunal modified such terms. The importer then approached the High Court praying for unconditional release of the goods on ground that they had been detained illegally and without service of any show cause notice under Section 124 of the Customs Act.
Before the High Court, the revenue challenged the plea for unconditional release of goods, stating that as the order of provisional release had been passed before the expiry of 6 months from the date of seizure, the second proviso to Section 1110(2) of the Act was applicable, by virtue of which there was no need for issuing an SCN within 6 months from the date of seizure of goods.
The High Court then drew attention to two significant amendments that had been made to Section 110 of the Customs Act, brought about by the Finance Act 2018 and with effect from March 28, 2018. The changes include the amendment of the wordings of the first proviso to Section 110 Clause 2 as well as insertion of a second proviso. It then drew attention to the fact that a show cause notice was subsequently issued on April 11, 2019 and whose adjudication proceedings were in progress.
The court then observed that the legislative intent was to ensure that any person whose goods were seized would not be left in a state of limbo, with neither the goods being released nor an SCN being issued, that too despite lapse of 6 months from the date of seizure of goods. It also clarified that the intent behind inserting the second proviso was to ensure that the provisional release of the goods is effected as quickly as possible.
The court observed that a valuable right might have accrued to the petitioner for unconditional release of goods if no provisional release order was pressed before lapse of 6 months from date of seizure of the goods. It also observed that the second proviso did contemplate provisional release of goods seized even when the provisions of Section 110 had been amended with effect from March 29, 2018. The High Court noted that such 6-month period had not lapsed in the present case. Therefore, no valuable right had yet accrued to the petitioner so as to seek unconditional release of the goods. It then clarified that the newly inserted section proviso could not be said to have applied retrospectively to deprive the petitioner of such valuable rights. With such observations, the petition seeking unconditional release of the goods was dismissed. Let us move to the next case.
The facts behind the present application for anticipatory bail, cut short, are that Narcotics Control Bureau received secret information that 2 parcels destined for the USA and Canada were lying at a branch of a noted courier company and that 1 parcel was suspected to contain a certain psychotropic substance. The parcel was intercepted and opened, whereupon several tablets of different chemical compositions were revealed. Upon testing, the contents of some of the tablets tested positive for known psychotropic substances. It was also found that the consignor of the parcels had on several occasions sent on such psychotropic tablets from his office-cum-warehouse.
Such premises of the consignor were searched, whereupon more such tablets were recovered. Moreover, some of these too tested positive for psychotropic substances. Once, such substance was trademark, of which more than 250 grams was recovered, hence classified as being in commercial quantity. The consignor was arrested and his voluntary statements recorded under Section 67 of the NDPS Act. He admitted his entire modus operandi as well as involvement of several other persons who were arrested as well. During investigation, the NCB found that a sum of over Rs 69 lakhs had been transferred to the applicant's account by one of the accused persons. The investigation found that there to be conspiracy amongst all these persons, which included the applicant as well. This led to the present application as the applicant apprehended being arrested by the NCB.
It may be noted that Section 37 of the NDPS Act mandates that before releasing a person on bail, the court has to record its satisfaction that reasonable ground exists for believing that the claimant is not guilty of the offence being alleged and that there is no likelihood of some offences being committed while claimant is released on bail. The court acknowledged that the secretive environments in which conspiracies were generally hatched made it difficult to fetch direct evidence of the same.
The court further observed that it was prima facie evident from the NCB investigation that all the accused persons were part of conspiracy and that they were all connected with each other in view of the statements recorded from the accused persons and from the evidence gathered by the NCB. It also acknowledged that anticipatory bail could be granted if evidence suggested that the prosecution was inherently doubtful or that there was a possibility of false implication.
The court also observed that when the element of criminality was involved or where custodial interrogation was required or other aspects and facts were to be unfolded upon investigation, in such cases anticipatory bail could not be granted. It is trite law that when considering such application for granting anticipatory bail, the court is obliged to look into the nature and gravity of the alleged offence and the claimant's role in it. The court also observed the need to also examine the claimant's antecedents and the possibility of the claimant fleeing from justice.
In the present case, the court found there to be no reasonable grounds which would satisfy it that the applicant was not likely to repeat such an offence, more so while being at large on bail. It also noted that custodial interrogation of the applicant was required to be so as to unearth, connect the wires of the conspiracy, the entire modus operandi at the involvement of the applicant and other persons too. Moreover, the investigation was only in the initial stage and the applicant was stated to have been non-cooperative and had not joined the investigation despite several of such notices. Considering such circumstances, the huge amount transferred and the gravity of the accusations, the court thought fit to reject the application for anticipatory bail. Let's proceed to the final case.
The facts in brief in this writ petition were that the petitioner company sought that directions be issued to the tribunal to hear its appeal on merits without insisting upon the mandatory requirements of having to pre-deposit a part of duty demand raised and penalty imposed under Section 129E of the Customs Act 1962. It also sought that direction be issued to treat the proceeds realized by the revenue from auction of goods seized from the petitioner as well as separate amount realized by invoking bank guarantee furnished along with B17 bond under Section 59 of the Act be treated as pre-deposit.
The court at the outset examined whether the petitioner was entitled to benefit of the pre-amendment provisions of Section 129E of the Customs Act since the right to file an appeal had accrued prior to its amendment. Post-amendment, an appellant was required to deposit 7.5% of the duty in case where duty and penalty are in dispute or penalty whether such penalty is in dispute in pursuance to a decision or an order passed by an officer of customs. Hence, it was observed that there is no provision for waiver of such pre-deposit of 7.5% of the duty and penalty payable.
The court also noted that the amended provision of Section 129E made it amply clear that they were inapplicable to stay application and appeals pending before the Appellate Authority prior to commencement of Finance Act 2014. Prior to such amendment, the Tribunal was vested with the discretion to dispense with the need for pre-deposit. Hence, the court held that the right to appeal is only a statutory one and could be hedged by conditions.
The petitioner contended that Section 6 of the General Clauses Act 1987 entailed that rights available to the petitioner could not be snatched by the amendment. However, the court rejected such contentions on the rationale that appellants would seek waiver of pre-deposits with vested interests in mind. It then clarified that right of appeal would be governed by the section which stood as on the date on which the appeal is sought to be filed. It was also held that Section 6 of the General Clauses Act, which deals with repeal, is inapplicable to situations where entire sections have been substituted. This brings us to the end of today's episode of Legal Wrangle. Please stay tuned to TIOLtube.com for our upcoming episodes. Please also share opinions and suggestions with us at editor@TIOL.in. Thank you for watching.